in his preliminary objection as was filed. 4, at the conclusion of the case for the defense, the parties shall each make their closing statements as appears on the hearing program, and the Senate shall accordingly, and the governor is invited to commence his defense and will have the original time of not more than 4 hours that was allocated. We will have a break at 1 p.m. for lunch. Honorable Senators, parties, ladies and gentlemen, please note that in accordance with Rule 29 of the impeachment rules, this ruling is final. Counsel for the Governor may now proceed.
Mr. Speaker, sir, as directed, we proceed to respond to the charges brought against the governor of Kiambu County. On the record of the Senate, the governor had filed a notice of preliminary objection that raised 4 points of law. As I shall start, and then my colleagues will argue the other 2 grounds, the second ground. Let me begin by stating that the governor pleaded not guilty to the charges. What is the effect of a plea of not guilty in this kind of proceedings? The effect of a plea of not guilty in this kind of proceedings, which are quasi-judicial, is that the burden immediately shifts to the county assembly to prove all the material particulars of the charges. We say that in particular respect because one of the material particulars they are supposed to demonstrate is that before the Senate, there is a valid motion, there is a valid resolution, there is a valid process that properly and in a manner provided for by law activated the jurisdiction of the Senate. The county assembly must demonstrate that the process that the Senate is called upon to interrogate, without that lack of demonstration, then there is the risk and possibility that the Senate is sitting on an unconstitutional motion. Allow me to make reference to the determination, a decision of the court made by the late Justice Onguto in the case of Mwangi wa Iria versus Murang'a County Assembly. It's a reported case. And paragraph 92 of that decision, the court said, the Senate must also interrogate the entire process as it's carried through the county assembly. I have seen no law that restrains the Senate from returning a verdict that the process was not conducted as detailed under the Constitution, as it went through the motions in the county assembly. Why do I say that? Because in the recitals read by the Speaker of this House on the material that was presented by the county assembly to the Senate, you will notice at the outset that one of the documents that were not provided, you were given a notice of motion, you were given an order paper, but you were not given a list of the members who voted in support of the resolution. That is a document that admittedly, and even by reference to the record, is absent. The second important fact that I want to refer to is that there was an admission by the witnesses, the witness of the county assembly, that that is information that was not brought to the Senate. And why is it material to us? We have determined, as the people of Kenya, and our Constitution, that we are a democratic nation that observes the principles of democratic governance. What is democratic governance? Democratic governance relates to validation of any act, any appointment, any resolution by a number threshold. Honorable senators, you are senators because of numbers. You won an election. The President of the Republic is the president because of numbers. In the Constitution, there is a litany of many enactments that are validated by certain number thresholds, even in this Senate. For example, and just by way of illustration, Article 115 on the question of budget and the veto of the president. There is clear prescription of a two-thirds majority for Senate or Parliament to veto such a recommendation. So, back to our case. What are the numbers required to pass a resolution impeaching the governor at the county assembly? Section 33 provides, at section 33, subsection subsection 3, subsection 2, if a motion under subsection 1 is supported by at least two-thirds of all the members in the county assembly, if a motion is supported by at least two-thirds, that is when it becomes a resolution in the context of section 33, capable of activating the jurisdiction of this Senate. If such a motion, however well prosecuted or argued, or however well meritorious an assembly may think it is, but short of the two-thirds majority, it does not result to a motion that is tenable and sustainable, and in the context of Section 33, can be capable of activating the process of removing a governor. What are the facts? What are the facts in this matter? And I say, and I speak to these facts, referring also to the investigative mandate of the Senate. The Senate, as earlier illustrated, search for the truth independently. The Senate has power to summon under the rules. Power to summon extends to the investigative mandate of the Senate. So part of the information that is available to the Senate to look at is the question of how many members participated in the passing of this resolution. It is our submission that this is a burden that is supposed to be demonstrated by the county assembly. Once you put in a preliminary objection impugning the validity of the resolution, then the burden shifts. In making this submission, the following facts are relevant. 35 members of the county assembly were not in the county assembly on the 19th of December 2019. This is a fact that can be independently verified by the Senate. This is a fact that Senate can call the county assembly into account, because attendance of an August House of any parliament is a documented fact. It cannot be left to conjecture, speculation, and equivocation. It is a fact that is put on record by way of a Hansard, by way of a biometric log, or by way of a register. This is public information that the Senate has capacity to take judicial notice of under the Evidence Act. It will be a sad day for the Senate and for the country if the Senate says we cannot inquire into the proceedings of the county assembly as we hear an impeachment motion. What then that means is that 3 members of the county assembly can wake up one day and bring a resolution to the Senate and say, quickly convene. The duty of the Senate under the Constitution and Article 96 is to protect counties and their institutions and their people. Part of this protection is interrogating what goes on in the county assembly and all the organs set out in the Constitution. You will see that the report of the Speaker says there were 64 members who were present in the House on that day. That was not given. There's nothing easier than providing a list of the 63 members who purportedly voted in support of the resolution and saying, these are the members who under Section 33(2) supported the motion. We have at our disposal on the evidence that the directions were members of the county assembly were not present. 33 of them have sworn affidavits, which they can be cross-examined on in any forum, not even in the Senate, even in court. And they have said, we were not in the county assembly. That is a material fact. It cannot be ignored, it cannot be avoided, it cannot be glossed over. This Senate has a responsibility to the people of Kiambu, to the nation, to confirm in the full evaluation of facts, you will find that the governor of Kiambu County was not impeached at the county assembly. The motion and the resolution that found its way to the Senate is untenable and unsustainable to the effect that it should be dismissed at the threshold. It is very easy for the Senate in its investigative mandate to call for even the CCTV records of the county assembly. It is our submission that this is a duty that in the past the Senate has dutifully and willingly carried out. In the special committee of this Senate, convened to investigate the matter of Honorable Mwangi Wairia, there arose the question of whether the governor was heard at the county assembly. The plea by the county assembly was, that is not a matter that the Senate should investigate. The Senate should just look at the motion, the resolution, and proceed. But this House said, no. We want to see the Hansard. We want to look at the invitation to the governor. And in the fullness of that evaluation, unfortunately, in that case, the Senate found that the governor had been properly notified. But the point I'm making is that Senate took time to call for facts and investigate that matter that was raised in the course of proceedings. It is in the report at page 75. In fact, Senate said that we as a special committee have a duty, and it's incumbent upon us to determine if there was any violation of the Constitution at the county assembly level. You're being told today, ignore the county assembly process, let's deal with what we have. That is not what the Constitution and the law provides. I urge you, honorable members, I urge you, senators, in your fairness to the governor, you have to interrogate this very material fact. And you must make a decision as to whether you are properly activated, you are properly seized of this matter. Because if you found that the number threshold was not attained, then the matter rests there. You have to down your tools because you are unconstitutional prescriptions. The Senate, similarly in the matter of Professor Kiprono Cheponi, which I had also occasion to appear for the county assembly, an issue arose and was raised by the governor on the question of whether or not there was public participation at the county assembly. And the Senate committee said, we cannot ignore that fact. It is an issue that affects the constitutionality of the resolution that you have brought to us. We must investigate it. And the Senate, if you look at that report, it's I think, 115 pages report. The Senate went into material detail, calling evidence, summoning persons to confirm whether or not there was public participation at the county assembly level. Because the effect or default thereof impugns directly the validity of the resolution, to the effect that the governor was not properly removed or impeached at the county assembly level. And therefore, in this matter of Governor Waititu, there may be many arguments, many allegations, many issues raised by the county assembly. Fair enough, it is their right. It is their right to want to remove the governor. It is the right of the Senate to hear and determine those charges. But it is also the right of Governor Waititu to receive the benefit of the law and due process. If you do not owe him anything else, you owe him that. The standard of the law and due process has to be applied not for the benefit of the governor, not for the benefit of the Senate, but for the institution of the rule of law that we have prescribed as a national value under Article 10. Yes, we may remove him, but let us remove him as the law prescribes. If the law says 2/3, we have to confirm that the 2/3 majority was attained. Numbers are democracy. And if those numbers were not attained at the county assembly level, then the resolution must fail. At the very least, we have to adhere to our constitutional principles, our constitutional standards, our precedents as the Senate. And I must say, I've been impressed by the Senate's insistence in all these reports on the adherence of the county assemblies on due process, threshold, nexus, and the standards that are now settled. In this matter, Governor Waititu, as a governor under Article 27 of the Constitution, deserves equal protection of the law. That is a right that is available to him, and we urge in the fullness of your consideration of this issue. You cannot be told that lack of numbers is a technicality. It is not a technicality. That question was settled by the Supreme Court in Raila Odinga petition of 2013, that where the Constitution prescribes a number threshold, then that number threshold is not a technicality. It is a substantive issue that must be demonstrated by evidence. And therefore, arguments will be raised that we have not presented evidence in regard to this issue. There was an admission before this House that it cannot be verified independently, even by a member of the County Assembly who moved the motion, that the numbers required to be realized were realized. Where there is such doubt, can you move? Can you move? Where there is such doubt, can you move then to remove the governor on the basis of that resolution? Where there is that ambiguity, then the benefit of doubt must be given to the governor. I rest by saying, on this question, my colleague will take up the other preliminary issue, that inasmuch as this matter relates to Kiambu County, it will settle the law on this unique issue, because that issue has never arisen in any of the impeachment questions that have come before this assembly. The question of numbers has never arisen. It is unique to these proceedings. And this is the opportunity for the Senate to insist on the county assembly that the requirements of removal under Section 33, the 1/3 approval, the 2/3 support must be strictly demonstrated before even such a resolution is admitted for hearing. Because it will be a sad day if we all gathered for 2-3 days to deliberate, discuss, and argue and determine a motion that is improperly before the House. That's why we raised this as a preliminary issue. It will be a manifest, unfair, and a very wasteful exercise if at the totality of the facts and the totality of the evidence demonstrated that indeed Senate was improperly moved. And therefore, honorable senators, it behoves this House, it is a responsibility that is given to you by the Constitution to investigate. And I repeat, investigation for emphasis, that this is not a contestation between two parties alone. This is a contestation between two parties and an investigative organ properly constituted and the law. The Senate has capacity to even summon the clerk, summon the speaker, call for those logs, and demonstrate independently, even without our input, the integrity of the vote. The integrity of the vote. The issue of electoral and voter fraud is a live issue in this country. When it's raised, the Senate cannot prevaricate on it. It has to look at it, call for evidence, and what we have before you is an admission on two things. First, that detail, those particulars were not given to the House. Secondly, the mover of the motion and the witnesses of the County Assembly, even in the face of the preliminary objection, which they admit they were served with, and they knew that the issue of numbers was an issue in these proceedings, they did not lead any evidence. And the burden is theirs. Once a governor pleads not guilty, the burden is theirs to prove that the number threshold was realized. It cannot be a presumption. It cannot be assumed. It has to be demonstrated by evidence, empirical, admissible evidence, to a threshold as required by law. That demonstration, that evidence is absent. And in its absence, then the unavoidable conclusion, and this is my plea to the Senate, it must find that without that evidence, then there is no proper resolution upon which the Senate can move to determine whether or not the charges are substantiated. I rest on that point, and I wish to invite my colleague, Mr. Wanyama, to urge the second point of our appeal. Thank you so much.
Good morning, Senators, Mr. Speaker, sir. My name is Peter Wanyama. I will be making submissions regarding a very fundamental point, which touches on these proceedings, the constitutionality and legality of these proceedings. Mr. Speaker, sir, we have a problem. These proceedings we submit in terms of compliance with the Constitution, the provisions of the County Government Act, and your own standing orders are a nullity in law. Nullity in the sense that there are certain legal questions which then lead to the conclusion that if those legal questions are considered, then in your decision when you are retiring to make the final vote on the charges facing the governor, you must address that question first. And the question is on the question of timelines. It is, I know, difficult for you yourselves to make this decision because the illegality in question arises from a decision of the Senate itself in these impeachment proceedings, and not an illegality that arises from the County Assembly proceedings. So as I said, it's a very difficult decision to make. In court, it's very easy for us to make submissions for judges to recuse themselves when they don't have jurisdiction. So we are only repeating it here, but now the forum is different. Now, Article 189 of the Constitution, 181 of the Constitution is express, clear, and unequivocal that the process of impeachment of a governor in accordance with the grounds laid in Article 181 of the Constitution shall be in accordance with the legislation enacted by Parliament. And the legislation in question is the County Government Act. The import of that is that the timelines which have been set in the County Government Act derive its validity from the Constitution itself. A response can be made that these timelines can be cured by the provisions of Article 159 of the Constitution, which provides that procedural technicalities are not supposed to impede access to justice. But our submission is that compliance with the provisions of the County Government Act is a constitutional imperative, is a constitutional command. The authority derives strictly from the Constitution, and therefore it can't be cured in any interpretation whatsoever. So in terms of that issue, it is important to emphasize that the Senate has no powers whatsoever to change provisions which have been put in statute. The only power that you have is to introduce an amendment to that section, which shall then go through the normal legislative process, and then the timelines will definitely change. So as it is, I'm going to make submissions that compliance with these timelines is strictly a fundamental legal question, and the Senate, if you look at the provisions of the Section 33 regarding the timelines, in summary, the Senate has breached these timelines by 28 days. The Senate has convened the statutory timelines which are have been provided for in Section 33 of the County Government Act. And that is very, very, very critical. You are late by 28 days. The import of that is that you have no jurisdiction whatsoever then to consider the allegations which were leveled by the County Assembly against the governor. An additional question. Does the Senate have powers to extend these timelines? Do you have statutory discretion? Because normally if timelines have been cast in statute and you read the statute in terms of interpretation, you will definitely find that some statutes can confer you with discretion to extend these timelines. So the logical question there is, do you have a constitutional or a statutory discretion to extend timelines by interpretation of the standing orders or by a ruling of the Speaker? My submission is that Section 33 has been cast in stone. Section 33 of the County Government has been cast in stone, and it doesn't give the Senate in terms of discretion whatsoever. I submit that discretion in this case has been taken away. And in law, we usually say that discretion is like the hole in the donut. Discretion must be exercised within the confines of the parameters of law. If the law has given you discretion, then just like the donut, you must exercise within that confines. Otherwise, any decision that we make which is outside that hole in the donut is a decision which we submit is ex facie illegal. It is unconstitutional and cannot be sustained at all. And I want to also emphasize in terms of decisions which have been made by this House. Remember, Mr. Speaker, sir, this is a House of President. There have been more than seven impeachment proceedings which have been conducted in this House. At no point in time during the impeachment of Governor Wambora did the Senate extend these timelines beyond the provisions of Section 33 of the County Government Act. In fact, during the impeachment of Governor Wambora, the Senate had to sit up to 4 a.m. in the morning to comply with the strict timelines in statute. So that is very, very significant. During the impeachment of Governor Chepkwony, this House had to be called on recess, to hear an important matter concerning the removal of Governor Chepkwony. During the impeachment of Governor Mwangi Wairia, timelines were strictly complied with. Section 33 of the county government strictly complied. There was no deviation whatsoever, even by a minute. During the impeachment of the late Governor Gachagua, again, timelines were complied with. During the impeachment of Governor Samboja, again, timelines were complied with. During the impeachment of the Deputy Governor of Machakos, timelines were complied with. Now, it begs a fundamental question, a very serious question, which we can't run away from. should Governor Waititu be subjected to a different impeachment test, a different impeachment threshold? What does it say about proceedings which are conducted in this House? What does it say about precedent, the rules regarding precedent which are binding to this House? What does it say about compliance with the Constitution on one fundamental question, which is the principle of equality before the law, which is a constitutional imperative, is a constitutional command. And let me just read it for the record and for the Hansard. Article 26 of the Constitution says, every person is equal before the law and has the right to equal protection and equal benefit of the law. Now, an impeachment proceedings which is being conducted in accordance with the provisions of Section 33 of the County Government Act, pursuant to the provisions of Article 181 of the Constitution, must be uniform. Every governor or deputy governor who comes before this then calls into question then the legality of the process. So you can see that it is clear beyond peradventure that Governor Waititu cannot be subjected to an impeachment proceedings which is done at the discretion of the Senate and outside the provisions of Section 33 of the County Government Act. So we can run away from that issue, but it's a live legal question. The courts have ruled on the question regarding equality before the law. Every person must be subjected to a similar treatment and must derive benefit from the law. So why should Governor Waititu be subjected to a process of impeachment which is done 28 days, which can be cured by the provisions of Article 159 of the Constitution? Another comparison is very, very important. Another comparison. There are strict timelines in Article 144 of the Constitution regarding the impeachment of president and deputy president. Because they are cast in law. They are cast in stone. They can't be deviated from. Changing those timelines, then it becomes a problem. So in terms of the interpretation of the law, we must interpret the law in a manner that we create a multiple basis for consistency in parliamentary decision making. So in this case, all we are asking for is consistency in parliamentary decision making. So there must be a multiple basis through which we exercise that power to interpret the law. So when you retire, that shall be the first and foremost issue. Sorry, first and foremost is in proper English. It shall be the first issue for this House to consider. It shall rank first in time. The moment you discover that Mr. Speaker made a mistake by convening this House 28, because the moment you allow that illegality, you are setting a dangerous precedent in the application of that particular section in this country's legal history. The other comparison, election petitions in law are strictly conducted within the timelines which have been set. It's just a comparison. There's no way you can extend the timelines which have been put by statute in terms of election petitions determination. Those timelines have been set, again, pursuant to a constitutional process and implemented by statute. And there are policy reasons why those timelines have been cast in that manner. There are policy reasons why it is important and critical that impeachment proceedings against a governor be determined within the statutory timelines provided for in Section 33 of the County Government Act. Remember that a governor is elected by the people, and therefore, Article 38(3) of the Constitution, the governor has a right to hold office. The governor has a right to hold that office once elected. It's a right in the Bill of Rights. And therefore, to take away that right, there can be no substantive impropriety in the process of taking away the governor's right to hold the office through an impeachment proceedings. And this taking away this technicality we submit is substantive. It is not merely a procedural question, which, as I submitted earlier, can be cured by the provisions of Article 159 of the Constitution, or a ruling of the Speaker varying the standing order. So we submit that the Honorable Speaker made a substantive and a fundamental mistake, a serious mistake, which casts doubt to the legality of these proceedings, and it can only be cured by a rejection of these proceedings. So let me just, were rejected. So I'll just read into the answer what the Supreme Court said concerning timelines. In the Raila Odinga, under Section 60 of the Evidence Act, courts of law are usually required to take judicial notice of the existence of decisions, of judgments and all that. So we submit that a similar comparison can be taken in this House, because it's a quasi-judicial process. Independent Electoral and Boundaries Commission and others, 2013 EKLR, the doctrine of judicial president, and therefore its decisions are binding, says, in respect to compliance with timelines, as a matter at paragraph 29, as a matter of fact, if the timelines are... So we can borrow the same submissions here. If compliance with Section 33, which derives its authority from Article 181, paragraph 2 of the Constitution, creates a technicality in terms of procedure, then when you are sitting as Parliament through an amendment of legislation to provide for other timelines. So, Mr. Speaker, sir, we are really emphasizing that issue because it's at the core of this impeachment proceedings. We are submitting, in summary, an official act of the Speaker in convening the House afraid that mistake by ruling that indeed you have no decision accordingly. And the decision, Mr. Speaker, sir, that we are seeking is a decision to reject the impeachment against the governor and determine that Mr. Speaker, sir, which we can emphasize now in terms of summary. Mr. Speaker, sir, the impeachment is a quasi-judicial process. And Mr. Speaker, sir, in view of that, there's a legal question which arises again in these proceedings. The legal question is, can the governor be subjected to impeachment proceedings based on matters which are sub judice? Mr. Speaker, sir, from the proceedings of the County Assembly, listen carefully to the submissions which were made by the County Assembly. It is clear that there are certain matters which are being canvassed in a court of law. And therefore, Mr. Speaker, sir, Standing Order number 98, your own rules of this, the rules of this House, prohibit discussion on matters which are sub judice. And the legal implication is that if you proceed to make a determination on that matter, you will be breaching that principle of sub judice, which is covered in your own standing orders. To make a decision on, if you find that they are in the proceedings which are in a court of law, we submit that you need to apply your rational mind, apply that rational basis test when you are deciding, not to look at that matter, because it will open up a Pandora box then of saying that you have breached the standing orders. Courts are prohibited also from looking at matters which are pending in Parliament. So in similar vein, then Parliament is prohibited from looking at matters which are pending in court. Mr. Speaker, so-called process, the so-called political questions are matters which this House can conveniently handle. An impeachment proceeding being a quasi-judicial proceedings, then proceeds on the basis that those questions can then be addressed so long as they are not pending in court. And if they are pending in court, it will heavily prejudice. It is like subjecting the governor to two processes. One, an impeachment proceedings, which is really quasi-judicial proceeding. And then the other one is a court process, which then undermines the rule of law. As I submit, there are also policy reasons why rule number 98 exists in the standing orders. Again, rule number 98 is meant to, again, lay basis for consistency in decision making, so that there is harmonious workings of the different arms of government. And therefore, the governor has a legitimate expectation that those matters which are in court then should not be considered here because they will heavily prejudice the governor. And when you're examining this question, I invite the House to look at the evidence which has been tendered by the County Assembly and the charge which the governor faces. Because that then will clear the issue in that perspective for determination by this court, so that we don't expose the governor to what is called a double jeopardy, subjecting him to two processes, and therefore it becomes extremely and highly prejudicial to the governor. So thank you very much. I'll be coming back later on to make submissions on the threshold on the County Assembly case. Thank you. That is all for the PO, Mr. Speaker, sir.
We are still arguing our POs. There are 4 points on the PO. I will be very, very brief on the 2 that are remaining. I do not want to tire honorable senators with legal arguments, but they're important. We are defending a man whose job is on the line. So kindly allow us to quickly go through the motions of our 2 other remaining arguments. First, in our PO, we have isolated the issue of compliance with the standing orders of the Kiambu County Assembly. And I'll do no more in that regard than refer honorable senators to standing order number 82 of the County Assembly of Kiambu that provides at part 2B that a special motion in the nature of a removal of governor by way of impeachment should be disposed of within 14 days. That is the prescription of the standing order. What is the factual reality of these proceedings? It is conceded by the move of the motion that the motion was introduced on the 3rd of December, 2019. It is also conceded, and the communication is clear from the Speaker, that that motion was argued and disposed of on the 19th of December. That was well outside the standing orders of the Kiambu County Assembly, which provide for a 14-period limitation. If it's not disposed of within 14 days, then that motion is no longer tenable, it's no longer sustainable, it's no longer arguable as a motion under Standing Order 82 and capable of activating the proceedings for the removal of the governor. Having said that, allow me to retract a bit on the issue of timelines and say that in evaluating how time is calculated for purposes of statutory interpretation, there are 2 ways. First, there are statutes which provide within themselves on how time should be interpreted. In default of such provision, then the Senate or any other judicial or quasi-judicial or any other organ or arbitral organ seized of a matter regarding time has to look at Chapter 2 of our laws. Chapter 2 provides for the interpretation and general provisions. Section 57 provides clearly that where a thing is to be done within a specific number of days, then those days are exclusive from the day in which the event runs to the day to which that event should have been done within the time given. What does that mean? When the Senate was served and was seized of this resolution on the 23rd of December, the law says 7 days, which should have expired on the 31st of December, unless that statute provides jurisdiction to extend that time, then that time cannot be extended. The analogy I gave is on election petitions. Some of you participated and even instructed some of us to act for you in election petitions. And the law is clear. In fact, the Supreme Court said, in the case of Lemanken Aramat, that the jurisdiction of the court to hear is inherently tied to the issue of time. And once a breach of this strict scheme of timelines is done, it removes the entire dispute from the jurisdiction of the Senate, of the court. Our submission in closing on that issue is that at the lapse of the statutory timeline granted by the County Governments Act, and that is the act and the law that grants this court, this Senate, jurisdiction to hear. The jurisdiction to hear an impeachment motion by the Senate is not in the Constitution. If you look at Article 96 and Article 181, it does not even mention Senate. Senate is mentioned under Section 33 with the limited function within the prescribed time. It is very difficult to make a decision that appears to undermine your established and governed by the law. So your first allegiance should be to the law. And that is our simple request, and that is our prayer, and that is our submission. The last issue that we raise as a preliminary objection is the question of public participation. And these issues are set out in our PO. And I will not urge any facts in support of that PO other than the deficiency or the complete lack of evidence by the County Assembly showing that there was any public participation. I remind the House that this is a settled issue by this House. The Senate said in the special committee considering the issue of Professor Chepkwony, Governor of Kericho, that public participation is a necessary constitutional prerequisite, and that has to be demonstrated by the County Assembly. That is a finding of the Senate. Senate is bound by its own finding. On the material that was presented before this House by the County Assembly, there was no evidence whatsoever of public participation. Court of Appeal in Civil Appeal number 192 of 2015, the case of Martin Nyaga Wambora, also spoke to that issue. And the court said, and I do not wish to read the entire judgment, but the court said that impeachment of a governor is such an important issue of a constitutional moment that the public ought to be facilitated by the County Assembly to participate in. And on that ground, so it is an issue that this House is enjoined to consider, and our submission is that absent any demonstration of public participation, then the resolution before this House is constitutionally deficient and incapable of supporting the removal of the governor of Kiambu County as proposed, and therefore must fail. We therefore pray and ask the Senate, honorable senators, to consider our interventions on points of law by way of this notice of preliminary objection, and in full evaluation thereof, you will find that they all have merit based on the evidence that is already on record and based on error under the Evidence Act. I shall now call my colleague to respond to the substantive issues raised in the charges.
Honorable Speaker, honorable senators, presented to this House by the Assembly. Mr. Speaker, following the directions and the ruling you gave, I will now speak to the factual and evidentiary deficiency of this impeachment as presented by the Assembly. Mr. Speaker, I will start my discussion on a rendition of what the standard that should be met by the Assembly is. An oft-cited decision, and I'm happy that the Assembly in their opening remarks cited it, is the decision in Martin, Nyaga, Wambora, and others versus the Speaker of the Senate, which is reported 2014 EKLR. And I want to start my discussion, Mr. Speaker, by quoting a finding of the Court of Appeal on what impeachable conduct constitutes. Mr. Speaker, the Court of Appeal had occasion to consider that matter, and in its wisdom gave the following rendition of the law: that to our minds, therefore, whether a conduct is gross or not will depend on the facts of each case, having regard to the article of the Constitution or the law alleged to have been violated. We find, however, that it is not every violation of the Constitution or written law can lead to the removal of a governor. It has to be a gross violation. So that, Mr. Speaker, this Senate may very well find certain violations, but not every violation of the law constitutes an impeachable offense. Mr. Speaker, in the same decision, the Court of Appeal went on to say that that violation must be serious, substantial, and weighty. So that this Senate, in its consideration of this impeachment motion, will need to ask itself, has that standard of being serious, substantial, and weighty been discharged by the Assembly? Mr. Speaker, I'll revisit that shortly as I delve deeper into the various allegations, Mr. Speaker. Mr. Speaker, in a case from the Supreme Court of Nigeria, again, which we had occasion to cite in previous impeachment, Honorable Muia Inakoju and Abraham Adeolu Adeke. The Supreme Court of Nigeria had occasion to consider again the issue of what an impeachable offense is, and had occasion to write. That explains why Section 188, I'm quoting that decision, talks about gross violations. Again, repeatedly, gross violations. Where a misconduct is not gross, then the weapon of removal is not available to the House of Assembly. That is the Supreme Court of Nigeria. So that, again, the question that you need to continually grapple with after having listened to the evidence that was tabled yesterday are those infractions. First of all, we will be showing you that they were not proved. But even if you are to find that they were, do they rise to the required standard? I'll revisit that in a short while. Mr. Speaker, there are various decisions. Again, I don't intend to take you through. There was Mwangi Wairia decision, which again I had the opportunity to participate in. And again, where violations were found, infractions were found, some of which mirrors what is before this Senate, including, Mr. Speaker, allegations touching on pending bills. But they were all rejected, not because they were not proved, but because in the wisdom of the Senate, they did not write the ground for removal. Mr. Speaker, in the same decision, Martin Wambora, this is a standard that the Court of Appeal set, that given that this is a sui generis, quasi-judicial investigative process, the standard is below a reasonable doubt.
So, Mr. Speaker, I want to seek the guidance of the chair. According to the program, we should, if any, or cross-examination or re-examination in chief, according to the program. Then, thereafter, we are supposed to receive closing statements on behalf of the governor. But having listened to counsel for the governor, I'm getting the impression that we have from the governor, where counsel is summing up the legal issues and making an address to the Senate. Can I have guidance from the chair whether we have altered the program, whether we are at the stage where we are getting closing statements, or we are at the stage where we are supposed to be receiving the evidence of the governor? Thank you, Mr. Speaker.
Senator Kabaka.
Mr. Speaker, sir, thank you. I don't agree with Senator Omogeni, senior counsel, with regard to what he's trying to tell this Honorable Senate, because already, Mr. Speaker, sir, you have ruled that there is no extension of time to submitting evidence. What other evidence does he require? The 4 critical points on the appeal. Thank you.
What's your point of order, Senator Murkomen?
The Speaker, you ruled earlier. You ruled yesterday first that the lawyers of the governor will make their application for PO together with the substantive response to the charges, which denied them the opportunity to make the PO before the county assembly makes its case. That prejudiced the governor from succeeding in this house later to bring evidence, because this house says, as a result of the ruling of yesterday, there cannot be other evidence because county assembly has closed its case. Now, there is no evidence that is admitted as per your ruling, meaning the only thing that the governor's advocates can do is to haze around without really going to any evidence, because there is no evidence as ruled by this house. And being a person who was supporting an admission of this evidence, you can see where we are going.
Senator James Orengo.
Mr. Speaker, if you look at the rules, there is some justification from what has been said by senior counsels, Senator Omugeni, and also what has been said by the leader of majority. The only confusion that is arising is that the counsels for the governor have termed what they are doing now as a preliminary objection. What I understood them to be doing is making a response to the case that has been laid out by the county assembly. And I think if they are presenting or reacting to the case that has been presented with the county assembly, then the governor should not be shut out. But there's going to be another opportunity when the closing statements are going to be made, only 30 minutes for closing, which means they've got to be very brief. I think it's 60. Yeah, 60 minutes. That's a very short time, actually. So I think they are doing the right thing, but calling it the wrong name. Because if it's a preliminary objection, for example, when they are saying we have no jurisdiction, they should not be had to be saying anything else other than talking on the question of jurisdiction. Because why you do want us to consider the evidence when we don't have jurisdiction? So I think is a misnomer for them to call it a preliminary objection. They should say they are making statements, including the statements they're making about jurisdiction, in answer to the case that has been made out by the county assembly.
Senator Mtula Kilonzo Jr.
Speaker, I'm of a different view that my learned friend Peter Wanyama has argued forcefully that we should down our tools and go home, and they're arguing many things. I think that since they have chosen the mambo jumbo and the recipe of what they want to do, we give them their time, argue as they please, end of their case. They have chosen what to do. I think if we intervene, then we'll be looking as if we want to advise them, and the governor has paid his legal counsel fees to advise him. So we are not supposed to advise them. Let them conduct their case. This time they have, them continue. We are going to sit here patiently, only that in the case of Wanyama, we never sat until 4 a.m. We can't sit until 4 a.m. So we will not sit until 4 a.m. Thank you, Speaker.
Senator Wetangula.
No, Speaker, the governor and his lawyers find themselves in a very difficult situation because ordinarily those of us who go to court, the sequencing of cases is not what they find themselves in. We've put them in a box where they are now supposed to navigate between a preliminary objection post-hearing situation we may find ourselves in. I think this House has the capacity to sift the wheat from the chaff at the end of the day and determine fairly when themselves in. At some point, I believe they'll call their client to testify, depending on what they want to do. And I'm sure this House and these distinguished senators are able to know how to skin the cat, whether start with the tail or the ears or the head or the back, whichever. Thank you, Mr. Speaker.
Okay, thank you for your inputs. I directed you proceed in the manner you are proceeding. If by the end of it, the statements will end up saying the same,